One of the biggest high-profile cases I've had the honor of being involved with in exposing the corruption that exists in our family court and guardianship court systems is the Angela.Freiner case out of St. Louis, Missouri. It had many of the same kind of bad court actors, which also used the same kind of tactics and legal loopholes to accomplish case fixing in order to achieve their agenda. As you will also see and recognize in this case, although this is a guardianship and probate court case in regards to the Hillygus family, make no mistake, they are using the same playbook as was used in the Angela.Freiner case. As we get into the details of the timeline and aspects of the case that are critical to understanding the nature of this racketeer-influenced corrupt organization, or RICO, and how it is connected to the Angela.Freiner case, as well as many others as of yet not named, you will clearly see the pattern of organized criminality through the family, guardianship, and probate courts, and how all three aspects of this racket are working hand in glove to achieve their end result. What is their end result, you ask? Well, in the family and CPS court system cases, they are unjustly removing children from loving and non-abusive parents and sending them to the abusers. Why on earth would a court system do this? Simple. They monetarily incentivized the Title IV grant money. In layman's terms, they get more federal funding per child that they have in their system. In Angie's case, the family court trafficked her daughter across state lines to a girls' boarding school known as Trinity Teen Solutions. Trinity Teen Solutions was known and suspected to be involved in child labor and human trafficking, and as recently as August 2022 was shut down due to an open lawsuit for child labor and human trafficking by multiple former students. In many of the probate and guardianship court cases, they are stealing people's assets, trusts, and property, and in many cases are intentionally using negligent and or understaffed care facilities whom are also over-medicating their elderly patients and owners of said assets, trusts, and property in order to hasten their demise. You'd be surprised how many times these cases involve spiteful or resentful family members of those whom are being unjustly and unlawfully targeted by these bad court actors. For the purposes of expediency and efficiency, this forensic timeline analysis will stick to the most relevant facts, evidence, and claims as they pertain to the Roger Hillygus case. However, any additional sources or evidence not prominently featured in the timeline analysis will be available to access through our unique horizontal scrolling source table directly below this video. In addition, this analysis will be done in the same common law fashion, i.e. precedent, as in a court of law, when having to meet the burden of proof standards. At the end of this analysis, you will have a deeper and more thorough understanding and grasp of corruption in the courts and how they operate from this modus operandi. You may view our reporting standards on how we cover these cases on the newsforus.world Terms of Service page under the Code of Conduct section.
I do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and the Constitution and government of the State of Nevada against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same, any ordinance, resolution, or law of any state notwithstanding, and that I will well and faithfully perform all the duties of the office of a Senior Justice of the Peace of the Nevada court system on which I am about to enter. So help me God.
This all started on October 1st, according to Roger's application for a temporary and or extended order for protection against domestic violence against his sister, Robin Renwick. The application was filed on December 24th, 2013 at 11:09 and 49 seconds a.m. Let's take a look at some of the claims Roger makes in his application for a TPO. Narration by Robin.Austin.
October 1st, verbal abuse. threatened to rain down legal and financial hardship, viciously and vehemently refused to remove her name from parents' joint U.S. bank account recommended by attorney Steve Moss while in his office. November 30th, threatened over phone to deny me access to residence at 2685 Nob Hill Drive. She illegally enters residence and room and removes various personal property, medical records, legal documents, journals, files, miscellaneous mail, etc. Admitted this to Washoe County Sheriff's Office, WCSO. Unauthorized reopening of parents' U.S. bank joint account. Removes $3,700, causing account to be overdrawn. Later apologizes for the wrongdoing. My wife and I called Washoe County Sheriff's Office, WCSO, non-emergency, and asked how to obtain a temporary protective order. December 2nd, she places a 911 call to WCSO, Washoe County Sheriff's Office, and falsely reports to dispatch that, quote, my brother is stealing all the personal property from residence 2685 Nob Hill, 9 p.m. Wife and I stopped by WCSO, Washoe County Sheriff's Office, to talk about threats and harassment while at Christmas dinner at Lakeside Manor. It was recommended by Washoe County Sheriff's Office to file temporary protective order, TPO. December 20th, she calls 911 emergency dispatch to Washoe County Sheriff's Office. Quote, my brother is illegally residing at 2685 Nob Hill and will not vacate premises. She was out of control, abusive, screaming, get the fuck out of here and take your dogs with you, or I will have all of you permanently removed. After Washoe County Sheriff's Office Deputy Vanderwall and Koos and others leave, she continued to invade my privacy. December 23rd, she attempted to gain access to 2685 by jimmying door locks, checking windows, told me previously she would gain access with the help of a locksmith. I'm fearful if she gains access to the residence, I have firearms and money in the home.
Roger's original application for a TPO gets dismissed without any due process or consideration for his evidence.
If either H. Eugene Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individuals shall act as trustee. On the death of both settlers, or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renwick shall serve as successor trustee. In witness whereof, the settlers set their hand and seal, and the trustees have caused these presents to be executed on the day and year first above written. Settlers, H. Eugene Hillygus, Susan L. Hillygus. Trustees, H. Eugene Hillygus, Susan L. Hillygus. State of Nevada, County of Washoe. On this 24th day of August, 2011, H. Eugene Hillygus and Susan L. Hillygus, as settlers and trustees, known or proved to me to be the same persons whose names are subscribed to the foregoing instrument, personally appeared before me and acknowledged that they executed the foregoing instrument freely and voluntarily for the uses and purposes herein expressed. Stephen C. Moss, Notary Public. All terms of Hillygus Family Trust, restated, dated August 17, 1993, shall remain the same except for the following. 1. The existing terms of Section 9.1.2 are deleted in their entirety and replaced with the following. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of both settlers, or the surviving settler, Adam Clark is appointed as successor trustee. Dated this 11th day of June, 2014. Take note of the date here, specifically the year. It says dated this 11th day of June, 2014, from the Law Office of Todd L. Torvinen, Chartered, Todd L. Torvinen, Esquire, Attorney for Robin Renwick. Certificate of Service. Pursuant to NRCP, Nevada Rules of Civil Procedure 5B, I certify that I am an employee of the Law Office of Todd L. Torvinen, and that on June 11, 2013, I served a copy of the foregoing document on the parties identified below by using the ECF system, which will send a notice of electronic filing to the following: Steve Moss, Esquire, Michael Springer, Esquire. Take note of the date here on the certificate of service, specifically the year. It says June 11th, 2013. Typo? Objection to petition regarding administration of revocable trust. Roger E. Hillygus, by and through his attorneys, Don L. Ross and Lauren D. Burkich of the law firm Woodburn and Wedge, hereby submits his objection to petition regarding administration of revocable trust filed by Stephen Moss, purportedly on behalf of H. Eugene Hillygus. This objection is based upon the following memorandum of points and authorities. Opposition in part to oral motion for the appointment of guardian ad litem. Memorandum of points and authorities. H. Eugene Hillygus, hereafter Gene, and Susan L. Hillygus, hereafter Sue, executed the trust agreement for the Hillygus Family Trust on August 17, 1993, attached hereto as Exhibit 1. Section 9.1.2 of the trust agreement provides as follows. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renwick shall serve as successor trustee. Date 6/12/2014. Dear Steve Moss, it appears as though you are not taking my verbal request to you over the phone, discharging you as my attorney. Seriously, let me refresh your memory about the events of that call. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and I hand-delivered to your office secretary, Cynthia, an original hand-signed letter by Roger discharging you as the attorney representing me and the Hillygus Family Trust. At that time, we both told Cynthia to send us any and all personal property and the complete file along with the final bill. You called me the next day and we spoke about this, and I informed you during that phone call that I no longer need or wanted you to represent me or the trust. You told me that pay the final bill would be $2,000. I am confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter. I am, however, disappointed that you are continuing to represent me after we mutually agreed to terminate our relationship. I realize that you believe me to be incapacitated and that you think you are protecting me from my son, Roger Hillygus. Nothing could be further from the truth. He is the successor trustee and the one I have always wanted to be placed in that position. So please consider this your official notice discharging you as my attorney. You are to cease and desist from any further actions, hearings, or petitions with the court on my behalf, or by representing any family member. Respectfully yours, Herbert Eugene Hillygus. Recommendation for order assuming jurisdiction over trust, order setting pretrial conference. The Commissioner held a duly noticed hearing on June 19, 2014, upon the petition regarding administration of revocable trust filed by H. Eugene Hillygus through his counsel, Stephen C. Moss, Esquire. Counsel Moss appeared at the hearing. Also appearing at the hearing were the following additional interested parties: Todd L. Torvina.
It's verified. The petition's verified. It's nonsense.
Esquire, representing Robin Hillygus Renwick,
How?
who joined in the petition. Sharon Januzzi, Esquire, representing Roger E. Hillygus, who opposed the petition. Sharon Januzzi, Esquire, representing Roger E. Hillygus, who opposed the petition. Not appearing was Susan Hillygus, co-settler of the trust, nor her counsel, Gordon R. Muir, Esquire, although the court is informed that he is still counsel for Susan Hillygus. The matter is contested. The Commissioner therefore scheduled the parties for a pretrial. The matter is contested. The Commissioner therefore scheduled the parties for a pre-trial conference on July 1st, 2014 at 4 p.m. before Department 4 of this court The Honorable Connie J. Steinheimer presided. The Commissioner made the following additional recommendations. The Court assumes jurisdiction over the Hillygus Family Trust, dated August 17, 1993. The Court declines to confirm the appointment of any successor trustee, although the record indicates that the same may have become necessary, based upon the incapacity of both settlers, H. Eugene Hillygus and Susan L. Hillygus. Instead, the pretrial conference date was expedited so as to allow these issues to be addressed soon, if necessary. The Court further declines to act upon the oral motions to appoint a guardian ad litem for either settler, and instead allows the opposing party, Roger E. Hillygus, to file his written opposition to that motion. Nothing in this portion of the recommendation, however, constitutes a finding that would bar a party from seeking further relief in this area or in continuing to pursue the pending petitions for appointment of adult guardians if the same becomes necessary or appropriate. Herbert Hillygus obituary. Herbert Eugene Hillygus, June 16, 1933, August 24, 2015. Herbert Eugene Hillygus passed away on August 24, 2015, at his home after a brief battle with cancer. He was 82. Gene was born in Santa Clara, California in 1933 to Stanley and Josephine Farrow Hillygus. Growing up, Gene spent time in Yerington, Nevada, Paso Robles, Templeton, and Jackson, California. Gene attended Taft Junior College, where he played basketball, football, and tennis. He graduated from Long Beach State with a Bachelor of Science and a master's degree in education. He was employed by Montebello Unified School District until he moved to Reno in 1972. Gene had a diverse career, which began in Reno as a counselor at Reno High School. He taught and was a dean at Truckee Meadows Community College, an advocate for the WCSD Administrators Association, and also a sales career at Dieter Lighting. He was a member of the Washoe County School Board and Reno Rotary. Gene was an avid outdoorsman, an educator, and people person. He always greeted everyone with a smile, never met a stranger, and he loved to dance. His numerous hobbies throughout his life included fishing, hunting, camping, and spending countless hours enjoying the outdoors and nature. He and his wife, Sue, enjoyed raising and riding horses and ran a successful horse boarding business for many years. They were both members of the Nevada White Hats Association. He is survived by his wife, Sue Hillygus, sons Randy Hillygus, and son and daughter-in-law Roger and Debbie Hillygus, daughter Robin Renwick, grandchildren Darla Clark and her husband
Adam Clark? Adam Clark.
Wait, Adam Clark? Could this be the same Adam Clark appointed as successor trustee in the First Amendment to the Hillygus Family Trust document?
Adam Clark?
And Landon and Sophie Renwick, great-grandchildren Seth and Gavin Clark, and friend Sammy Brooks. A celebration of life is scheduled for Sunday, September 27th at 2 p.m., Walton's Funeral Home, Ross Burke and Noble Chapel, 2155 Keatskey Lane, Reno, Nevada. All are invited to attend a reception to follow at 11380 Parma Court, Reno, Nevada, 89521. Note of the parcel number here, 552-171-04. This will become relevant later in the timeline. Homestead document dated 11/05/2015, 12:06:37 p.m. Case number PR 14-00025/GR 14-00159. In the matter of the Hillygus Family Trust, dated August 17, 1993. In the matter of the guardianship of the person and estate of Susan L. Hillygus. Notice of right to a jury being applied to this case per the Nevada Constitution, Article 1, Section 3, inviolate for
Sec. 3. Trial by jury, waiver in civil cases. The right of trial by jury shall be secured to all and remain inviolate forever, but a jury trial may be waived by the parties in all civil cases in the manner to be prescribed by law, and in civil cases, if 3/4 of the jurors agree upon a verdict, it shall stand and have the same force and effect as a verdict by the whole jury, provided the legislature by a law passed by a 2/3 vote of all the members elected to each branch thereof may require a unanimous verdict notwithstanding this provision.
forever. Legal arguments. Arguments why the state, the court, and the petitioners feel they are justified and compelled to keep Susan L. Hillygus incarcerated and isolated in a private locked facility, denying a mother-son relationship. Case number PR 14-0025, case number GR 14-0159, Department number 7. In the matter of Hillygus Family Trust, dated August 17, 1993, PR 14-0025. In the matter of the guardianship of the person and estate of Susan L. Hillygus, mother, GR 14-0159. Jury verdict and options available to the court. Honorable Judge Egan Walker. This is notice to the court that a jury has examined the evidence which was approved by the opposing counsels via acquiescence, and they have determined and stated in their unanimous verdict that there is not clear and convincing evidence that familial rights must be terminated to protect the parents, and that all orders of this court that interfere with familial rights, as stated in the Hillygus Family Trust documents, are void and unenforceable. Options: 1. Order the immediate release of mother to son's custody and conform to all trust documents as ordered. 2. Convene your own jury to decide this matter. No law prohibits a jury. 3. Or provide findings of fact and conclusions of law explaining how this court is not subject to the authorities listed in paragraphs 1 and 2 of the attached notice to judges. All other legal authorities are subordinate to the Nevada Constitution, inviolate, and the jury has made their decision. The court has until close of business, Friday, July 26, 2019, to respond to preclude actions described in subsection 4.4. Affirmation. Nevada Revised Statutes 239. No Social Security numbers are anywhere. Dated this 19th day of July, 2019. Signed Roger Hillygus, son. Case numbers PR 14-0025 and GR 14-0159. Second Judicial District Court, Nevada, County of Washoe. Guardianship and estate of Susan Hillygus. Judge Egan Walker. Reference documents for and against termination of familial rights dated June 25, 2019. Documents meet the confidentiality requirements of 42 United States Code subsections 5106A. This court has been duly noticed of defendant's right to have a jury decide this case. The judge declined to furnish a jury, leaving that responsibility to defendant per the attached notice to judges. The above-mentioned documents have been presented to an 8-person jury panel, and they have produced a unanimous verdict as follows. 2. Jury verdict. The state has not met the standard of clear and convincing evidence that the son is dangerous or abusive to his parents, such that the state is compelled to intervene in this family. Wherefore, all orders that diminish the force of law established by the family trust documents are void and unenforceable. This verdict is effective immediately and may be overturned only by a jury provided by the court under its authorities per Article 3. The court has discretion to utilize its own jury at any time. The right to a jury remains inviolate regardless of the results of the court's discretion. 3. This court now has the discretion to choose any of the options in Section 4, page 2 of the attached notice to judges. 4.2 issues orders that conform to jury verdict. Return mother. 4.3 convene the court's own jury. 4.4 deal with defiance of the Constitution noted. 4. Seventh Amendment. No fact tried by a jury shall be otherwise re-examined in any court of the United States. No place does it say, quote, a judicial order may not be re-examined by a jury. Only the word, quote, inviolate controls in this matter. Notice of judgment. The encumbrance of 2685 Nob Hill Drive, Reno, Nevada, 85906. Presiding Judge Egan Walker. This is notice to all concerned that the real property, 2685 Nob Hill Drive, Reno, Nevada, 85906, is subject to sole and exclusive ownership by the Hillygus Family Trust, of which Roger Hillygus is the sole successor trustee. All orders to the contrary, and prior to the verdict rendered on July 11, 2019, are void and unenforceable. Any actions or transfer of title to this property without the current expressed written consent of the trustee, Mr. Roger Hillygus, may either be negotiated to the satisfaction of the trustee or a satisfactory resolution shall be adjudicated in a court of law.
Absolutely. Okay. She put me in charge of her, as her power of attorney. I'm her successor trustee to her trust. Okay. I'm her son. Okay. I've cared for her already, and I'm going to continue to care for her. I'm retired fireman.
Okay. Perfect. How long has she been in the care facility?
3 years.
3 years. Are you concerned that the facility is not going to want you to take her?
A little bit.
Okay, why is that? That's what I guess I'm getting at.
Because when I was there visiting her with a witness, it was all videoed.
Gotcha.
I was holding her hand, like loving my mother.
Yeah.
And they said, you have to leave, you're upsetting your mother. And I said, what are you talking about?
Okay.
And they said, well, we've called the police. And I'm like, why? I'm sitting here with a witness. It's videoed. She's loving that I'm there holding her hand. I'm not upsetting her.
Yeah.
And I cared for my mother for 3 years.
Absolutely.
And I've lived with her for, a lot of my life, and I want to continue to care for her.
Okay, perfect. Did she voluntarily go into the care center, or was she placed there by somebody?
They placed her in there.
Who placed her?
The guardian that's been now removed from the jury.
Oh, okay, so there was another guardian involved.
There was one, yeah.
Okay, and they placed her there.
Yep.
And so was there a dispute between you and the former guardian about who should have guardianship of your mother?
There was false allegations made against me, but they were investigated, and I was proven to be there was no allegations that were shown to have affected me.
Okay.
It was investigated. I wasn't convicted. I wasn't arrested. I didn't do anything wrong. I'm not a criminal.
No. Okay. So what's the judgment that you got? What's the judgment say?
It says that I'm her. The original trust documents are back in place.
Okay.
which I have, and the original power of attorney, and that all the orders from the court are null and void and unenforceable. The jury verdict controls the position that I have with respect to taking care of my mother.
And where is Stone Valley, just so I know, in case they call us for some reason? Alright, so what brought you down here? I mean, I understand you want a sample standby. Obviously, we don't do that unless we have some reason. Because we're not here to enforce these court orders. I mean, we don't. And why we would even get involved, I have no idea. Normally, the civil deputies over at the courthouse, if there's a judgment from the court, it gets handed to them, and the civil deputies handle it. So I don't know. I mean, the police department, we don't enforce any civil orders, period. And obviously, you're there to get your mother.
I'm trying to come to you guys to explain to you that,
But
I've got all the authority to do this.
Like I said, we're not involved. We don't get involved in civil judgments, period. Either side. I don't even care what the judge ruled. The judge ruled that you have full power to walk in there and take the whole facility. That has nothing to do with us. That's a civil judgment. The government has no interest in that, so why would we get involved? So, what I'm saying to you is if you get up there, I would bring all your documents. I wouldn't just walk in there and grab her. I'd go see the management of the facility, show them your documents, explain to them rationally, here's my plan, here's what I'm doing, this is why I'm doing it, this is all the documentation that I have. Can you help me fulfill the orders of this so I can get my mom?
Every time I'd gone to see her, there was something that she wasn't being taken care of.
Okay.
And one-on-one care of a son versus one person with 17 people.
I hear you. Absolutely.
Every time I went there was issues with my mother not being cared for.
Yeah.
So, with Susan's meds, is there anything on this list that, if not taken as prescribed, is life-threatening?
Just Ativan, and Risperdal.
Can Risperdal cause death in the elderly? Risperdal has been shown to increase the risk of death in elderly patients with dementia. More elderly dementia patients have died from pneumonia, cardiac failure, and stroke, while Risperdal and the increased risk were not related to the dose amount or how long the medication had been taken. Though the exact cause is unknown, patients with dementia may be more at risk as they are unable to report severe symptoms. Because of the number of deaths, the FDA required that a black box warning be added to prescribing information for Risperdal. A black box warning is the most severe warning that can be issued by the FDA and requires that information is printed at the top of prescribing information surrounded by a thick black border.
And this one for the anxiety.
Well, nobody's ever died from anxiety that I know of, but
No,
as
I
far
don't
as
think
any...
so. No, yeah, that's also it is. Yeah, this is the opposite vitamin D. I don't think so.
Yeah, that's what I didn't think so. I just wanted to double check with you.
No.
Okay.
This is just for anxiety.
Right. Okay. Thank you.
I need you to call down there. 925,000. Try to get back through to his medical assistant. I need a prescription of lorazepam for that resident.
230.
Lorazepam. Important warning. Lorazepam may increase the risk of serious or life-threatening breathing problems, sedation, or coma if used along with certain medications. Tell your doctor if you are taking or plan to take certain medications for cough or for pain that contain opiates. Example: codeine, hydrocodone, morphine, oxycodone, tramadol. Your doctor may need to change the dosages of your medications and will monitor you carefully. If you take lorazepam with any of these medications and you develop any of the following symptoms, call your doctor immediately or seek emergency medical care immediately. Unusual dizziness, lightheadedness, extreme sleepiness, slowed or difficult breathing, or unresponsiveness. Be sure that your caregiver or family members know which symptoms may be serious so they can call the doctor or emergency medical care if you are unable to seek treatment on your own.
At first I thought that he would do that because that's what he's done in the past.
To have them fax
To try
us a script for her so that we can get her some medication so she calms down.
He is married?
He's
That's aggressive. Do you know that the sheriffs had to remove him with the SWAT team from this house?
From your mom's house?
And the sheriffs wouldn't do it without a court order because he threatened that he had guns. And he does have guns. So if they go out to Dayton, they need to be aware what they could possibly be walking into.
And we'll let them know.
Except for this part. Public record. You know, what's going to happen to my mom after...
Well, she's not on her meds. She's not going to have her meds. She's not going to get changed. I mean, there's crazy stuff going on. This is a copy of what he said. This is your copy.
No, she can barely walk.
No, he was dragging her. Not literally dragging her,
I'm surprised he didn't pick her up.
pulling her.
Yeah, I'm shocked.
My
It's
mom,
assigned to a detective.
okay, but do you understand that my mom's life is in danger right now? In danger.
How?
How?
How? She's with your brother.
Have you heard all the stories that we've been going through? That
I understand he has. He may have some
medications. So you
Okay.
believe that he's not a hazard?
None of your mother's. No, she doesn't. All of her. No, she doesn't. Because I just talked to the med tech because I got a list of her meds, and I confirmed with the med tech because all of her meds are primarily for anxiety, mental health. It's not for. There's nothing physical that if your mom does not take medications, she's going to die from. And I confirmed that with the med tech.
This is the hearing where they got the emergency TPO, which they used as a false basis for persecuting Roger without any recourse of due process and selling the home the day after Roger rescued his mother from Stone Valley Care Facility.
You were aware of what happened, right? Here's a little more. Apparently, he shows up with another goon, and he says, I'm signing Alice out. He goes and gets Mrs. Hillygus, and there's a witness who sees them pulling her, shoving her across the parking lot. He was pinged in Truckee, apparently. Was that this morning or yesterday?
Yesterday.
And this, really, it's a crime. It's a crime of kidnapping. It could be a crime of, that's a Class B felony, probably. Isolation, elder abuse. Problematic. Anyway, I don't want to get sidetracked on that. We're here to confirm the property. I'm sorry I interrupted you. The title company is balking at a close any sooner than 30 days because they're afraid that Mr. Hillygus is going to appeal. And I think this is what I'm about to say is true, is a matter of law, that upon sale to a bona fide purchaser in good faith, his cause of action, if any, from this sale is against the trustee and not against the real property. Would you be willing to add that to the order? I'm hoping it gives the title company some comfort so we could get this thing closed sooner.
Any objection to that, Mr. Spitzer?
No, Your Honor.
I would likely sign such a thing.
Before we go too far down this, I just want to make sure you don't have any quarrel with this, Mr. Spitzer.
I have no quarrel with that, Your Honor. You do have immediate authority under NRS 159.334 to issue a no contact order under the guardianship statutes.
Mr. Earle?
My only additional thought is under NRS 159.305 that you're dealing with just general exploitation, potential abuse, and so forth, and under those statutes, then likewise the guardian would have authority or an interested party.
And my thought about a domestic violence protection order is this, is it's registrable. In other words, it'll go into a state and national database, and it may have more legs, for lack of a better term, than simply, I of course order that Mr. Hillygus have no contact with a protected person in this case, and that is pursuant to Chapter 159. But let's see if we can establish whether or not there's testimony to warrant a domestic violence protection order. So, ma'am, would you kindly stand, raise your right hand, and take the oath of a witness?
Do you solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
And they allowed him out thinking that he was the son, and he was allowed to take her out, even though in her file he is not. His name is not on the list of people that are allowed to remove her from the facility. There's a picture in the back room of him but it didn't look like him.
Let's test that theory with the picture she is referring to and the Reno PD body cam footage of Roger asking them for a civil standby. Let's see what we find with what we have. He sure does look the same to me in the picture as he does in the body cam footage.
Let's move now next to the accounting. With that clarification going forward, I'll approve the accounting.
But under NRS 200.310.2, a person who is willfully, without authority of law, seizes, takes, carries, or kidnaps another person is guilty of Class B felony. To find here in open court today that there's PC with regard to that criminal statute, Class B felony kidnapping.
I think I would do a disservice to the process in this case if I were to step in out of order any more than I already have. Let me be more clear. It's fairly unusual for a district judge sitting with family division jurisdiction, as I do in this guardianship area, to sua sponte issue a protection order. It's been done before. I've done it before. I've never seen a successful challenge to it, and so I believe it's within the jurisdiction of me as a district judge. There is a process, however, in the criminal side. You know I am now a criminal judge. The law enforcement authorities are going to have to approach the district attorney's office to seek either a warrant for the arrest of Mr. Hillygus, or they will detain and arrest him on allegations of probable cause. It would not be appropriate, I think, for me to opine at this juncture as to whether or not there is adequate probable cause. I just think that would be stepping outside the bounds of my role at this time.
When this first happened yesterday, my clients, both of them, ran into the following milieu. Oh, it's just between a brother and a sister. This is a civil matter, when really it's not. And that's what I'm trying to overcome here. I just want you to understand that, where that's coming from.
Well, I can tell you that in my view, there are a variety of paths that could be taken to recover the person of Miss Hillygus. More specifically, what I mean is I believe there could be an analogous action for a retake warrant, in the way that if a parent secretes a child in a contested custody proceeding, there is a process to allow me to issue a warrant to include the arrest and detention of the parent or the bad acting parent who is secreting.
Wow, talk about violating your judge's oath of office. So much for avoiding the appearance of impropriety, and so much for upholding the state and federal constitution, eh?
It would be a UCCJEA.
Correct.
Okay, and
And
there's an equivalent in
the UCCJEA applies in Chapter 159
Okay.
cases by
Yes,
definition.
right.
And so there may be a mechanism for a retake warrant, as it were, related to the person of Miss Susan Hillygus. Apart from that, law enforcement is very aware of this case, I can tell you. It would appear to me there is an active investigation. It would appear to me there is some reason to believe that Mr. Hillygus has kidnapped, falsely imprisoned, and or unlawfully detains the person of Susan Hillygus.
Okay. I think that's all I have before you today, Your Honor.
Anything else, Mr. Spitzer?
No, thank you, Your
Or
Honor.
Mr. Earl?
No, thank you.
Thank you all very much for your time. Ladies, good day
Thank you
to you.
very much.
You're welcome.
Jurisdictional disputes regarding children in Las Vegas, helping families throughout Clark County. In Nevada, custody disputes are governed by the Uniform Child Custody Jurisdiction Enforcement Act, which is commonly referred to as the UCJIA. The UCJIA determines whether or not the Nevada court has the ability to consider custodial disputes. Basic questions we ask in all custody disputes include the following. Are there any custodial orders from other jurisdictions? Where has the child resided for the last 6 months? Has the child been outside the state of Nevada in the last 6 months? If so, why? Who lives with the child? If there are already custody orders, regardless of what state made them, does the child or one of the parents continue to reside in that state? The answers to these questions help us assess if the state of Nevada is the proper place to establish or modify a custodial order. If a child moved to Nevada or moved from Nevada close to a 6-month date, Then of particular importance is the exact date of the arrival or move date and any proof that a parent may have regarding that date. Even if a child has not been in the state of Nevada for 6 months, NRS 125A.335 permits the court in the state of Nevada to exercise emergency jurisdiction and to make temporary orders if the child is located in the state of Nevada. There are specific factual elements that must be met for the court to take the action, but it can happen in limited situations. Under the right set of circumstances, those temporary orders can become permanent orders. Under the UGA, Nevada judges are encouraged to schedule a teleconference with judges in other jurisdictions when there is a dispute regarding which state has the authority to rule on custodial issues. Regularly, attorneys appear at UGA teleconferences and are permitted to argue a parent's position regarding custody.
There is so much more to cover in this case. What you have seen here doesn't even begin to scratch the surface. We will be covering this in more depth in the days and weeks to come. For now, I will leave you with our last piece of evidence for this video.
What to do, Mr. Hanthe?
Judge, under the Sixth Amendment, I'm allowed to represent myself.
Well, let's not talk about whether
okay,
hold on. Let's not talk about whether the court should exercise its discretion or make a finding. Is that what you want to do? You want to represent yourself?
Correct, sir.
Yes or no?
Yes.
All right. I'm not taking that up now. How come? I don't have time for this. It wasn't set for this. We're on the eve of trial. I have other things to do. However, I will take this matter up Monday morning at 8:45 a.m. I've already set a hearing on the motion to quash. We'll take this matter up first. And then if you end up representing yourself, we're going to go right into the motion to quash with you being self-represented. If the request is denied, we're going to go right into motion to quash. Mr. Silverberg remains your counsel.
Okay? Do you have a bond to sit on the bench, Judge?
Pardon me?
Do you have a bond to sit on the bench?
So that's enough, Mr. Hanthe. You can have a seat.
8:45
Monday morning, Mr. Hanthe.
I understand that, Judge. This court has forced counsel upon me, and it's violation of Rule 1.16 and the Sixth Amendment.
Okay, Mr. Hanthe, thank you. I understand your position. You're wrong. You're wrong. You're wrong in many different ways. You're also being disrespectful to the court.
I'll sit down.
State of Nevada Executive Department Certificate of Election bears the Great Seal of the State of Nevada. This is to certify that at a general election held in the state of Nevada on the 3rd day of November 2020, Barry Lewis Breslow was duly elected to the office of Judge of the 2nd Judicial District of the state of Nevada, Department 8, for a term of 6 years from and after the 4th day of January 2021. Now, therefore, I, Steve Sisolak, Governor of the state of Nevada, by the authority vested in me by the Constitution and laws thereof, do hereby commission him, the said Barry Lewis Breslow, as a judge of the 2nd Judicial District of the state of Nevada, Department 8, and authorize him to discharge the duties of said office according to law, and to hold and enjoy the same, together with all powers, privileges, and emoluments thereunto appertaining. In testimony thereof, I have hereunto set my hand and caused the Great Seal of the state of Nevada to be affixed on this 30th day of December, 2020. And it is signed with a squiggly line that I suppose is supposed to be Steve Sisolak, Governor of the state of Nevada, and by the Secretary of the state of Nevada.
Former governor now, actually, but yeah.
Yeah, former Governor of the state of Nevada, Steve Sisolak. And it is signed with a squiggly line that I suppose is supposed to be the former governor of the state of Nevada, Steve Sisolak, and by the Secretary of the state of Nevada, Barbara K. Sagosky. I, Barry Lewis Breslow, do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and the Constitution and government of the state of Nevada against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same, any ordinance, resolution, or law of any state notwithstanding, and that I will well and faithfully perform all the duties of the office of Judge of the 2nd Judicial District of the state of Nevada, Department 8, on which I'm about to enter. So help me God. Barry Lewis Breslow. Subscribed and sworn to before me this 4th day of January AD 2021. And there's an illegible signature, which it's difficult to make out exactly who that would be, but it's not the Chief Justice of the Supreme Court that I guess ordinarily signs these documents, because that's scribbled out and it says Chief Judge 2nd Judicial Court.
More updates and evidence on this case soon. Thank you for watching.